The UK Supreme Court ruled that a woman is someone born biologically female, excluding transgender people from the legal definition in a long-running dispute between a feminist group and the Scottish government. Several women's groups that supported the appeal celebrated outside the court and hailed it as a major victory in their effort to protect spaces designated for women. 5 judges ruled unanimously that the UK Equality Act means trans women can be excluded from some groups in single-sex spaces, such as changing rooms, homeless shelters, swimming areas, and medical or counseling services provided only to women. The ruling means that a transgender person with a certificate that recognizes them as female should not be considered a woman for equality purposes. The ruling brings some clarity in the UK to a contentious issue that has polarized politics in some other countries. Particularly the US Republican-controlled states over the last 4 years have been banning gender-affirming care for minors, barring transgender women and girls from sports competitions that align with their gender, and restricting which public bathrooms transgender people can use. Since returning to the office in January, President Donald Trump has signed orders to define the sexes as only male and female, and has tried to kick transgender service members out of the military, block federal spending on gender-affirming care for those under 19, and block their sports participation nationally. His efforts are being challenged in court. Justice Patrick Hodge said the British ruling does not remove protection from trans people, who are still protected from discrimination under UK law. The case stems from a 2018 law passed by the Scottish Parliament saying 50% of the membership of the boards of Scottish public bodies should be women. Transgender women with gender recognition certificates were to be included in meeting the quota. The British government welcomed the ruling, saying it would provide clarity and confidence for women. Single-sex spaces are protected in law and will always be protected by this government, it said. Scotland's semi-autonomous government said it accepted the judgment. Opponents, including Amnesty International, said excluding transgender people from sex discrimination protections conflicted with human rights laws. Amnesty submitted a brief in court saying it was concerned about the deterioration of the rights of trans people in the UK and abroad.
The unanimous decision of this court is that the terms woman and sex in the Equality Act 2010 refer to a biological woman and biological sex. But we counsel against reading this judgment as a triumph of one or more groups in our society at the expense of another. It is not. As I shall explain later in this hand-down speech, the Equality Act 2010 gives transgender people protection not only against discrimination through the protected characteristic of gender reassignment, but also against direct discrimination, indirect discrimination, and harassment in substance in their acquired gender. This is the application of the principle of discrimination by association. Those statutory protections are available to transgender people whether or not they possess a gender recognition certificate. The questions which this court addresses have arisen in this way. The Scottish Parliament has sought to increase the representation of women on the boards of public bodies by enacting the Public Boards Scotland Act 2018. I will refer to that Act as the 2018 Act. The current challenges relates to the statutory guidance which the Scottish Government issued in 2022, following a successful legal challenge to the statutory definition of a woman in the 2018 Act and to the original statutory guidance. In the revised guidance, the Scottish Government, relying on its interpretation of the Equality Act 2010, asserts that woman, for the purposes of the 2018 Act, includes a trans woman who possesses a full gender recognition certificate, acknowledging her required sex as that of a woman. The campaigning charity For Women Scotland challenge the legality of that statutory guidance and submit that it is both wrong in law and beyond the competency of the Scottish Government. This challenge was rejected by both the outer house and the inner house of the Court of Session in Edinburgh. The courts held that Section 9.1 of the Gender Recognition Act 2004, which I'll now refer to as the GRA, had the effect that a person with a gender recognition certificate was entitled to be treated in law as having his or her acquired gender for all purposes. They addressed Section 9.3 of the GRA, which provides that the rule in Section 9.1 is, and I quote, subject to provision made by this Act or any other enactment or any subordinate legislation. The courts held that Section 9.3 has effect only if the terms and context of the subsequent enactment require it to be interpreted as disapplying the Section 9.1 rule. They held that the Equality Act 2010, which I'll now refer to as the EA, did not require such an interpretation except possibly in the provisions relating to pregnancy and maternity. 4 Women Scotland appeal to this court. Their appeal is opposed by the Scottish ministers. The principal elements of our reasoning can be summarised in the following 9 points. First, the EA enacts group-based protections against discrimination on the grounds, among others, of sex and gender reassignment, and imposes duties of positive action on employers and others. Secondly, the EA must be interpreted in a clear and consistent way so that those on whom the Act imposes obligations can identify the groups which share a protected characteristic. Thirdly, interpreting sex as certificated sex would cut across the definitions of man and woman in the EA, and thus the protected characteristic of sex, in an incoherent way. It would create heterogeneous groupings. Fourthly, as a matter of ordinary language, the provisions relating to sex discrimination, and especially those relating to pregnancy and maternity, and to protection from risks specifically affecting women, can only be interpreted as referring to biological sex. Fifthly, we reject the suggestion that these words can bear a variable meaning, so that in the provisions relating to pregnancy and maternity, the EA is referring to biological sex only, while elsewhere it refers to certificated sex as well. This undermines the coherence of the statute. Sixthly, the interpretation favoured by the EHRC and the Scottish ministers would create 2 subgroups within those who share the protected characteristic of gender reassignment, giving trans persons who possess a gender recognition certificate greater rights than those who do not. Those seeking to perform their obligations under the Act would have no obvious means of distinguishing between the 2 subgroups to whom different duties were owed, particularly since they could not ask persons whether they had obtained a gender recognition certificate, as that information is private. Seventhly, the certificated sex interpretation would also seriously weaken the protections given to those with the protected characteristic of sexual orientation, for example, by interfering with their ability to have lesbian-only spaces and associations. Eighthly, other provisions will function properly only if sex is interpreted as biological sex. Those provisions include separate spaces and single-sex services, including changing rooms, hostels, and medical services, and communal accommodation. And ninthly, similar incoherence and impracticability arise in the operation of provisions relating to single-sex characteristic associations and charities, women's fair participation in sport, the operation of the public sector equality duty, and the armed forces. Standing back, we note that the EHRC has advised the United Kingdom government of problems created by the certificated sex interpretation of the EA. Those problems include several matters in the 9 points which we have described. In our view, the absence of coherence within the statute and the practical problems which arise demonstrate that that interpretation is not correct. It follows that the interpretation of woman in the Scottish Government guidance on the 2018 Act is incorrect, and the challenge to that guidance succeeds. It also follows that the 2018 Act, correctly interpreted, is within the legislative competence of the Scottish Parliament. Finally, as I flagged up earlier, the correct interpretation of the EA as referring to biological sex does not cause disadvantage to trans people whether or not they possess a gender recognition certificate. Trans people have the rights which attach to the protected characteristic of gender reassignment.